Oh, yay, oh, yay, oh, yay. This Honorable Court of Criminal Appeals of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Thank you, Mr. Hivner. Good morning, everyone. This is day 2 of the January docket for the Tennessee Court of Criminal Appeals here in the middle section of the great state of Tennessee. And my name's Robert Wiedemeyer. I live here in Nashville. I have 2 excellent colleagues with me today, Judge Robert L. Holloway Jr. from Columbia and Judge Timothy L. Easter from Williamson County. We are operating with the Zoom docket due to the pandemic, and we would much prefer, of course, to be in the courtroom and handle things in the normal fashion. But that being said, we're also very grateful that we have the technology available from the Administrative Office of the Courts, and through the hard work of those folks, plus Jim Hivner and his staff, plus our staff attorneys. We appreciate that, their efforts, so that we can proceed with oral arguments on those cases where oral argument is requested. We'll conduct today's arguments as closely as possible to the way we would conduct them pre-pandemic, and that includes the fact that each side has 20 minutes to argue. If you're the appellant and you wish to reserve part of your 20 minutes for rebuttal time, please let me know when you begin your argument, and I'll help you keep track of your time. Also, I will advise counsel that we have read your briefs, so we are familiar with the case in that respect. We have not been assigned the records yet, but keep in mind that we have read the briefs. If that helps you tailor your arguments today. Are there any preliminary matters, Mr. Hivner?
No, Your Honor, there are not.
All right, thank you. If you'll call the first case on today's docket, please.
State of Tennessee versus Rickey LaRon Houston Church, in Ray 911 Bail Bonding, LLC, surety.
All right, thank you. Mr. Olson?
Yes, sir.
You ready to proceed?
Yes, sir, we are.
All right.
Your Honor, on behalf of my client, 911 Bail Bonding, I would like to reserve 5 minutes. I don't think that we'll use all our time, since Your Honors have all had an opportunity to review this. I am very thankful we're able to continue doing the people's business despite this terrible virus that we're experiencing. But that being said, Your Honor, this is a case involving my client, 911 Bail Bonding. This is entirely post-judgment. And by that, I mean the criminal judgment in this case is concluded. Mr. Houston Church was charged with an offense in Montgomery County and appeared before the circuit court. He was bonded out of the jail by 911 Bail Bonding. I'm just going to go through the facts that are in the record very quickly that I feel are the most pertinent. Mr. Church he had been ill, but he suffered from, and during the time period that this was ongoing, was debilitated by multiple sclerosis. He was no longer even able to drive. He was no longer able to get around during the time periods that he was in the courthouse. When I saw him, actually, when we were doing this, and the record reflects, Mr. Church was in a wheelchair. He was not able to really articulate things. Ultimately, Mr. Church, as he was bonded out, went back to California, and he disappeared. And it really isn't something I think that was, I don't know that he was absconding so much because of his illness. He moved in with a relative and totally went off the grid. He did not have money to buy a cell phone. He did not have anything to assist him in communication. So what happened was we lost Mr. Church, and he began to not appear in court. 911 bail bonding, my clients undertook significant research to find him. Ultimately, he was located in California at a relative's home. He was arrested out in California on an NCIC warrant, and my client's 911 bail bonding got him in California and drove him back across the country, stopping many times because he had MS, and resulting in returning him to the court. Ultimately, again, the state resolved Mr. Church's criminal charges, and he was released and sent back to California. I did not participate in that, but I'm certain that the physical condition that Mr. Church presented had significant impact on that. For the purposes of the bond, we had a hearing in this case, the transcript of which your honors have or will have, that reflected that Mr. Church had been returned. At the time we had the transcript, Mr. Church was in the courtroom, had the hearing, Mr. Church was in the courtroom. We weren't really able to question him too much because he'd come back. He did not at that time have counsel. And from my recollection and the transcript, he was not asked any questions because he was a criminal defendant and he had his Fifth Amendment rights. But it's clear that he was returned. He's in the courtroom, and the bonding company had then, in my opinion, fulfilled the obligations that it had to make him present. Now, it is clear.
Had the final forfeiture already been taken at that time?
It had.
Had the final forfeiture been taken at the time you found where he was in California?
Yes.
And so he left the state of Tennessee, went to California, did not show up for his court appearances, and you say it's questionable whether he absconded?
I'm taken by the fact that I was there and saw his physical condition. I'm on the bonding company's team. I was there on behalf of the bonding company, but this was a fellow who was debilitated by his condition and was not someone. He by the time he got back to Clarksville, he was even in a situation where he was having difficulty feeding himself. So,
Mr. Olson, is what you're arguing right now in the record his physical condition, and in this theory that even if he wanted to abscond, he didn't have the physical ability to do that? Is that in the record that we're going to read?
I do not believe that you will see that type of thing in the record, but you will see that the court acknowledges that Mr. Church is present in the courtroom and he is present in a wheelchair. As a matter of fact, from my recollection, as he tried to speak, there was some difficulty understanding him because he had very great difficulty speaking. So,
well, let me back up just a second.
Sure.
I wanted to let you set the groundwork for this case. The state has alleged that we do not have jurisdiction to hear this case because the order that was appealed from appears to be the original order that was entered by the court back in July of 2019, where, as I understand it, the whole bond was forfeited, $50,000 bond was forfeited. And looking at the record that we have before us, that's the order that was appealed from, not the later order where apparently some partial judgment was entered, where a certain amount of money, was it $15,000? I don't know if 15 was returned or 15 was the total judgment. But in any event, my question is, what do you say about the state's position that we do not have jurisdiction to hear this? Because the order that was appealed from, according to our record, is the July 16th order.
I would disagree with that. The entire case is before the court. It is not something that is a pick and choose type deal. If that's the case, then what's the basis for the court reducing it to 15,000? And I'm not trying to argue against my client's position, but clearly this court continued on having jurisdiction, and clearly the court acted in this case, and clearly the court accepted Mr. Church's return by my clients. The trial court, yes, sir.
But at that time, when all that hearing was taking place in August of 2019, wasn't there a notice of appeal already pending in this court?
Very well, yes, because we had a duty to take some action, but the court record comes up with the changes that were made. The statutory scheme is clear. 40-11-208 allows this specific action in the cases before this court, Your Honor.
Okay.
It's just unfortunately, if we don't do something at the time, we're likely to be bumped out. But then we have a statutory scheme that allows us to come forward and request relief based upon the fact that we've fulfilled our duties and we have provided the defendant, and that's in fact what happened. So that's what the subsequent motion was filed under 40-11-203, and addressing that, it's pretty clear to me that the statute says exonerated from all costs if the court finds that the bondsman has no fault. Respectfully, in this case, I've searched this record, and I don't know, we don't look at the fact that the person did not appear, because if that were the case, then that would be end of story. We're done every time a person has a forfeiture. In this case, what the court has to look at, and what the court did look at and find that there was some basis for reduction, is the bond company without fault? And I've had a bunch of these hearings here recently, it seems, where the trial court looks at it and says, okay, well, I'm going to reduce this, saying that we find that there's some basis for the reduction, but I'm not going to reduce it all the way. And respectfully, I don't know that comports with the statute of 40-11-208. Now, I recognize in large measure that there's some discretion here. I do recognize that. But as our brief makes clear, there is an ability for the court to abuse its discretion. And respectfully, in this case, I don't know of a case that would be more so than this case. The cost of bringing this man was introduced. I think Your Honor, Judge Easter asked about the record. Much of what the record demonstrated was the expense that was incurred by my clients and the difficulties that was incurred by my clients in returning this man across the country. And
the court gave you $35,000.
That's correct.
Wasn't that to reimburse for these expenses?
No, sir, I don't believe that was it. The court did take that into account because it came into the record how much was expended. But I think what the court did was the court just said, I'm not going to hold you to this entire amount. The question, and really this, I think, comes down to, in my mind, the ultimate goal of what this process is. This man was present, albeit he was not at original dates, but he was made present and was afforded justice by the state of Tennessee and by our local district attorney's office. That was not something that cost the state of Tennessee. That was not something that cost the people of the state of Tennessee. That was something that cost the bondsman who made the bond. And in my estimation, the question becomes, if you've done that, what is the abuse that is presented, or is it just intended to be a windfall for the state or county? I don't know that it's intended to be a windfall. I believe that it is intended to make sure that justice is done. In this case, justice was done. And respectfully, I'll be honest, I was kind of shocked again. We were not without communication with the district attorney's office. Hey, this guy's sick, we can't find him. This guy's sick, we can't find him. Not good enough, we want the money. And that's in the record too. Not good enough, we want the money. And respectfully, I don't think that this is intended to be a lottery system. It's my impression this was intended to be a system that is designed to assure the presence of the defendant. And in this case, that is in fact what happened. And unless Your Honor unless the court may have additional questions.
Well, I have a question.
Yes,
During the entire, let me start with this. Did the 911 bail bonding company know this man had physical disabilities at the time they made the bond?
Yes, but not to the extent that he had. He was ambulatory. He was walking. He was charged with a criminal offense that wouldn't involve somebody in a wheelchair. So the answer would be yes. I believe that they were aware that he had some physical difficulties because they had communication with his family, and this is my recollection, who made the bond.
And throughout the entire time this case was pending, I assume there were regular hearings set before the trial court in which the district attorney was there, had to participate, found out where the defendant was. They had to call out the bond. They had to go through various stages, correct?
Yes, sir, they did.
So there was some, damage is not the word, some cost, at least in time and court dates to the state by the bond company failing to deliver him at the trial date.
I think that it would be an incorrect. I'm doing something with my volume here. I'm sorry. I think it would be incorrect on me to say that there was no cost, but I don't know how you would judge that cost when the typical docket, and Judge Wiedemeyer, who was a criminal judge in Montgomery County, would know this at one point, consists of 60 or 70 cases. And his would be one of those 60 or 70 cases. But is there some cost? I would say that there's obviously some cost that's related, but I would also say that the clerk's office charges money for each and every time there's an appearance in court. So Mr. Houston Church was left with that additional cost. But yes, I would think there was some additional cost, but I think it would be de minimis.
The August 21st, 2019 hearing on the motion, at least that's the date it appears to me that it took place.
Yes.
The state said there was no proof offered at that hearing. Is that correct or incorrect?
That is not correct. And again, I don't know the specific dates that we took place, but we had a gentleman by the name of Billy, I believe it's Billy Suter was the fellow who actually drove out there. We provided testimony from bonding agents, and I believe that it may have been a subsequent date when Mr. Houston Church was present, but at one point Mr. Houston Church was also present, which was I believe memorialized in a transcript.
That may be the date where they authorized those two agents to go out there.
Could be, very well could be, very well could be. Because we actually had some difficulty. It's an odd system. My experience with the bonding companies is it used to be if somebody didn't show up, the bonding company could go down and actually prosecute a failure to appear, and it would be included in the NCIC. That's not the way it works anymore, at least in Montgomery County. Now you have to go through the district attorney's office to obtain an NCIC warrant, and we actually did that. And then we hired folks out in California. We made contact with the sheriff's department in the county that he lived in, and I honestly don't remember what county it was. It was a big county in California, and they arranged to arrest him if we hired bail bondsmen in California to get him, and that's what we did. That's exactly how he came into custody. A bail bondsman went to his house that we hired. They had to take a van. He was rolled out into the van. He was taken to the local sheriff. He was held there until we appeared, and then we drove him across country. But unless your honors have any other questions, I would submit that this is a case where it's not a windfall to the state. My clients did what they were supposed to do. Mr. Church, interestingly enough, again, came back here and was released very quickly to go back to California. I can only envision what it was, but I don't think that the jail in any way desired to have Mr. Church as a permanent resident because of his physical condition at the time. But I thank you all for your attention. Thank you.
All right, certainly. Good morning, General Lee. You ready to proceed?
Yes. Good morning, Your Honors. May it please the court. Sophia Lee on behalf of the state. Your Honors, I just want to be very clear. There's some confusion regarding what is actually properly before this court, and I think that's the more pressing issue before this court reaches the merits. We've got the initial judgment, which was for full forfeiture of the entire, I believe, $50,000 amount. And then we've got another judgment with partial forfeiture. So even before this court were to reach the merits, the initial question has to be, what is properly before this court? The problem in this particular case is after the trial court entered the judgment of full forfeiture, the surety filed a timely notice of appeal. It is well established when a party files a notice of appeal that divests jurisdiction from the trial court and invests jurisdiction in this court. Usually in these kinds of situations, you've got a judgment of final forfeiture, and then sometimes there's a petition to rehear. We don't have that in this particular case. So we've got a notice of appeal, and it's timely filed. And so everything that happened after that notice of appeal was filed, we submit that it's a nullity. It's very comparable to what I'm familiar with and what this court is familiar with, and that would be a motion for new trial. So if you were to take a traditional criminal case where there has been a conviction, a sentencing, and the defendant decides to go ahead and just file a notice of appeal, but if for some reason the defendant decides, I'm going to raise a suppression issue or something else and decides to file a motion for new trial, it is well established that no matter what the trial court decides to do, the trial court, even if they rule on that motion of new trial, after a timely notice of appeal has been filed, it's considered a nullity.
Ms. Lee, and I hear what you're saying, and that was my thought when I first read your brief. But it sounds like Mr. Olson is saying that the bail bonding statutes take that into consideration, and there's some sort of statutory provision that will allow for a case in the posture that this case is in to proceed without being able to claim we don't have jurisdiction, although there was a previous order appealed. Have you reviewed the bail bonding statutes too?
Yes, Your Honor. And I'd like to invite the court's attention to two particular statutes. That would be 4011-203 and 4011-204. Now, esteemed counsel is arguing for his client's position under 4011-203. We submit that this court should actually pay more attention to 4011-204. Well, actually, it really kind of depends on the statute makes a distinction between whether the judgment has been paid. That's the two distinction between the two particular statutes. So under 4011-203, if the judgment has not been paid, the trial court will then look to 4011-203, determine whether or not relief is warranted. Of course, it all depends on whether or not the judgment has been paid. And actually, I'm afraid I'm not quite certain. I don't believe the judgment was paid. So I believe that 4011-204 would actually imply in this particular case, regardless, our Supreme Court recently affirmed the fact that when this court reviews these kinds of questions, it's for abuse of discretion and not de novo review. So even though 4011-203 specifically states discretionary authority, and there really isn't any mention of 4011-204, both issues have to be addressed for 4011 for abuse of discretion. Now, going back to 4011-204, it's really interesting because in that particular statute, it says, and I usually don't like to read, but I think it's important to do so here. The judges of the General Sessions, Circuit, Criminal, and Supreme Courts may receive, hear, and determine the petition of any person who claims relief is merited on any recognizance forfeited. And I think, as I mentioned before, the distinction between these two statutes is whether or not the judgment has been paid. And of course, this presents actually a golden opportunity for this court to actually provide some guidance, to clarify, to affirm what needs to be done in these particular situations. Specifically, does a trial court retain jurisdiction on these kinds of cases? Now, esteemed counsel talks about being on a particular team. We all share the same overarching interest. The state, the surety, the courts. If there is a defendant who has fled, we all share the same overarching goal, and that is that defendant needs to be brought back to justice. That defendant needs to be apprehended. So in that sense, we're all on the same team. And so in terms of whether the trial court retains simultaneous jurisdiction, the Supreme Court actually frowns on that. It's not a good use of judicial resources. There's only one particular case that I've come across, or one particular type of case in which it's been held that it's okay for a trial court to retain jurisdiction, and that would be in parenting agreements. And without going into full detail, that's kind of understandable when you're talking about the custody of children. But in other cases, especially in criminal cases, I mean, there's really no situation where the trial court and this court would retain jurisdiction at the same time. There are situations where, at least in my experience, where this court, when you've got an appellant who decides at the appellant stage that he or she wants to proceed pro se. Now, I've seen orders where this court will send it back and have the trial court determine whether or not that's what the appellant wants to do. But that's not the situation that we have in this particular case. We've got a judgment, and I don't think there's any issue that there was any problems in terms of a notice of hearing. There was a capias, there was a conditional forfeiture. Apparently, if you look at the trial court's initial order, 180 days had passed, there was no action. And so the trial court was justified in entering that judgment of final forfeiture. The problem in this particular case is the notice of appeal. And again, this presents a golden opportunity for this court to determine, number one, because we've got a published opinion by this court saying that the rules of civil procedure apply. The rules of civil procedure, before it actually reaches this court, there's a couple of I think, mechanisms in which when a judge enters a judgment, there is an opportunity for the party to file a motion to kind of rehear that. We don't have that in this particular situation. We certainly don't have that in criminal cases, whether it's post-conviction or habeas or any other situation. We are not unaware that the defendant, fortunately, was apprehended and brought back to justice. The problem is, if you look at the timeline, you've got a capias that was issued back in, I believe it was August 2018. And apparently nothing was done until after the judgment of final forfeiture was entered. Now, I mean, when I say nothing was done, the defendant wasn't actually apprehended until after the judgment of final forfeiture was entered. I guess, unless the court has any further questions regarding the first issue, I just want to clarify that just based on the timing, based on what the party chose to do, what the trial court did, the trial court had no jurisdiction to enter that judgment of partial forfeiture after the surety filed its notice of appeal. And I've come across no authority that would resurrect the trial court's authority, that somehow that they retain continuing jurisdiction, although I would invite the court's attention to 4011-204 for guidance. I'll just go ahead and move on to, I guess, the basis of the appellant's issue regarding the discretion exercised by the trial court. Whether it's the full forfeiture or the partial forfeiture, our position is the trial court did not abuse its discretion. It's wide discretionary authority. They had a hearing. There were two hearings. I want to be very clear. There was absolutely no proof at the first hearing. There was proof at the second hearing. And I believe the agent who actually apprehended the defendant actually traveled with the defendant from California. He did testify, but that was at the second hearing after the defendant was apprehended. The defendant did make an appearance at the second hearing, but as my esteemed colleague pointed out, he did not testify because he was not represented by counsel. But in terms of what the trial court chose to do in this particular instance, the trial court, in terms of the partial forfeiture, took all of these things into consideration. The fact that the defendant was apprehended, that there was some cost to the surety. Apparently, because of California law, they couldn't just go in and grab the defendant. And so they needed to hire someone from California. So that's all before the record. The trial court considered this, and instead of entering a judgment of full forfeiture, chose to enter a judgment of partial forfeiture. And we submit that based on the evidence in this case, the trial court properly exercised its discretion in granting partial forfeiture. Unless the court has further questions, we submit that the judgment that was entered after the appellant filed its notice of appeal was a nullity, is not properly before this court. However, should this court find that the judgment is properly before this court, the trial court properly exercised its discretion. Thank you, Your Honors.
Thank you, General. You've got a couple of minutes left for rebuttal there. In fact, I'll let you have your entire 5 minutes since we asked you so many questions, Mr. Old.
I'm happy to try and streamline it. I think you all have a good feel for what's going on. I think the question as to whether or not the court can act or not act is defined by Tennessee Code 4011-204. And again, I don't read stuff to courts who certainly can read, but that statute is the one that allows the court to make a change with regards to the payment. And respectfully, there's not something there that says it has to be done within 30 days or anything. It can be done 2 years later. And in fact, people will come in frequently and make application for a reduction, even a year after someone failed to appear. But the statute in the last sentence makes very clear the power to this power, which is the power to lessen the liability of the bonding company, shall extend to the relief of those against whom final judgment has been entered, whether or not the judgment has been paid, as well as to the relief of those against whom proceedings are in progress. Respectfully, I think that I appreciate counsel's argument, and very novel in a way, I think, but the statute provides for the fact that occasionally criminal defendants abscond, and occasionally people have to come in and ask for relief when, in fact, someone has been found and brought back. Now, again, this is not, in my opinion, the absconding part of that statute. This is the part where Your Honors have to look at it, and I believe the court made a logical assumption that this situation was in the situation it was, the posture it was, because of my client's inability to do something or failure to do something. And respectfully, because of the manner by which that this gentleman presented himself, because of the manner of this man's physical condition was presented, it was really impossible to find him. He dropped off the radar. And I believe you'll find in the record there's discussion by our bail bondsman about what was done to try and find him. And they actually had to do some digging, and I think they even offered bounty money for him. Hey, return him and we will find out. We will pay you for information. But we believe in this case it was an abuse of discretion. There's nothing more that I believe my clients could have done. And this is something that I think I just don't want to hit this too hard, but I think this is important. Bail bond is something that is constitutionally mandated. You shall be admitted to reasonable bail. And I don't think that we can read more or less into these statutes than is there. The court has discretion, absolutely has discretion, but the court has to make a determination as to whether or not my clients were at fault. And respectfully, this is not a situation where I believe my clients were at fault. But anyway, that would be our argument, unless the court would have additional questions. And I thank you all.
I have one question, Mr. Olson.
Yes, sir.
So your argument that the notice of appeal from the original judgment can now apply to the partial forfeiture of judgment later when the judge returned the $35,000 is based on 204, that last sentence about this power?
Yes, sir. Power shall extend to the relief of those against whom final judgment has been entered, whether or not judgment has been paid, as well as to the relief of those against whom proceedings are in progress. And proceedings is not defined, but if you read the statute, which I think is pretty clear from the face, it has to do with we've entered a forfeiture. There are proceedings that are ongoing. Proceedings could be any number of things. They could be collection proceedings. They could be this appeal. They could be, in fact, the fact that we have filed this petition for relief. So, it's sort of you're danged if you don't, you're danged if you do. If we didn't file that initial objection, actually appeal, I feel confident that at that point the state would be saying, oh no, we are too late. 30 days has run. The rules of civil procedure apply. And in fact, that's not what was intended, because this is a slightly different area of the law, and the statute specifically recognizes that.
So the way I understand it, in certain cases, you could file this notice of appeal from the final forfeiture. You could pay the bond, and 2 years later, you find the defendant. You come in and have an exoneration or partial exoneration hearing, and then you can go back and rely on the original notice of appeal without filing a notice of appeal from the new order entered 2 years later by the court, partially exonerating the bondsman.
That's not what I'm saying at all. What I'm saying is that if we were going to appeal the judge's decision regarding the $50,000, the original forfeiture, we had 30 days to do that. We absolutely had 30 days to do that. We also had the right under the statutory scheme that counsel has talked about, 203 and 204, which both of us discussed in our briefs. We also have the right to come back and ask the court to relieve us from the $50,000 judgment, which in fact happened, and we paid the $15,000. So if we hadn't paid that, I think we would not have been in a position to even go forward, because they'd shut down the company. But yes, the question becomes yes. Now, I also believe, I think in looking at what Your Honor says, let's assume that it was 2 years later and the notice of appeal had run its course. This honorable court said, nah, you're all wet, go on back. At that point, under the statute, we would still have the right to come in and ask for relief, which we did. But that doesn't stop the process of relief. We're entitled to continue doing that. And I don't think that we're required to do something new with regards to the notice of appeal, simply because of the manner by which the statute is written. And it is a little bit different than any other area that I've experienced, but it is slightly different than any other area I've experienced. Because if counsel wants to, the logical end of this is, okay, if you don't file that appeal, the $50,000 stands. Okay, well, what's the right that we have then 2 years later to come in and ask for relief? We still have that right.
Right, and that's what I would think. You'd still have that right, and if you're denied that right, you'd at that time file a notice of appeal based on the denial of that right.
Yes, sir, except that the case is already on appeal.
So it's 2 years later. So we got this case on appeal about the final forfeiture of the $50,000 that just sits there for forever until something comes up and you file for exoneration after having found the defendant. That's how
it works. I mean, you file. The Court of Appeals clearly is going to act within 2 years, but that's not really the question. The question is, does the exoneration statute allow the court to do something notwithstanding the judgment of the Court of Appeals? It does. It allows the court to have a hearing and to go forward. And that is a part of the record that is actually before this court, because it is something that was heard during the time period before the matter came before the court. And that is specifically provided by 204. Whether it's been entered and paid, as well as relief against those whom proceedings are in progress. And obviously this proceeding was in progress. So I think that this is a part of the record. And, to do otherwise, I think is, I don't know, it makes no logical sense based upon the statute, in my opinion.
All right. Any other questions from my colleagues?
I just had one out of curiosity,
Yes,
Judge Whitmire, if you'll indulge me with this, because you're here asking for the $15,000 back, not 50, but 15,
yes.
Right? Do we have the authority to say, well, Judge Goodman was partially right about this, but instead of 15, it should have been 20. Do you think this court has the authority to modify it to some other number, or is it an all or nothing proposition?
I think what the court has to focus in on is, did the court abuse its discretion? I think that is the substantive law that the court has to look at. Did the court abuse its discretion in this situation?
But could we say the court abused its discretion in arriving at $15,000? But based on our review of the record, $20,000 might be more reasonable.
I think there's really no more record that justifies that than justifies the $15,000.
Okay. We'll see.
Hopefully that won't happen.
As I say, it was more out of curiosity than anything.
Well, I understand, and I don't think, it's an interesting area, and having participated in these reduction hearings, it's slightly different because of the manner by which it wasn't just your typical defendant absconding, and the focus, in my opinion, has to be the fault of the bondsman. What was the fault of the bondsman in this case? And respectfully, that's, I think, the focus that's required. But thank you all very much.
Does the record show when you started looking for him?
Yes, it does. The record demonstrates that they attempted, I think they attempted money. Hey, we will pay you to tell me where. They were contacting. The way that this works, the bonding company keeps contacts for all the people. And ultimately, and I don't remember exactly who it was, but one of the family members said, well, yeah, he's over at so-and-so's house. He can't get around good anymore. And they were like, he's at so-and-so's house. So they went to get him, and they called actually. And as I recall, and this I'd be corrected by the record, but they called and said, yeah, he's here. He can't get around very good. So they sent people to get him and arrested him and then drove him back. And it was, the bondsman talked about it. It was quite an ordeal to get a MS patient from California to Tennessee. And then respectfully, Miss Helen Young and the local sheriff were not very, they didn't want to keep him. They sent him back.
All right. Good arguments by both sides. Good briefs as well. We appreciate that. We'll take the matter under advisement and get an opinion out as quickly as possible. We'll be in recess until 11 o'clock. Is that correct?
Yes, Your Honor. This honorable court is now in recess until 11 a.m.
Thank you.
Thank you.